The
Right.
Pretrial Fairness Act obviously is very new. So everything that I'm saying to you is subject to change as there's more appellate review of what's going on. I'm going to be talking to you specifically about how things are being handled in Winnebago County. Other jurisdictions might be handling different parts of the Pretrial Fairness Act in their own way. Also, every judge is able to interpret the act as they see is appropriate. So there might be differences between how different judges, even within the 17th Judicial Circuit or in Winnebago County, or even in the Criminal Justice Center where I am right now, how we interpret things. But much of the act does incorporate parts of or concerns relating to domestic violence. And so I'm just going to go through that with you, and then I am happy to answer any questions if I do know the answer. So here we go. So the learning objectives today are to discuss what is the Pretrial Fairness Act? What impact does it have on domestic violence cases? What impact on criminal orders of protection? What are we doing with defendants who are currently in custody prior to September 18th at midnight when the act went into effect? What is the impact on defendants that have original warrants? What impact on arrests post the implementation of the Pretrial Fairness Act? Then I'll be talking about how Winnebago County specifically is responding relating to detention hearings, petitions to reconsider conditions of release, petitions to revoke pretrial release, orders of protection. And then I just want to assure from the start that there are things that are not changing because of the Pretrial Fairness Act. There will still be no contact orders that can be entered as conditions of somebody's pretrial release that we used to enter in conditions of bond. There are still charges of violation of pretrial release. And if somebody is charged with violating pretrial release, we used to call that violation of bail bond, there can still be charges. Marcy's Law, which we often think of as the Crime Victim Bill of Rights, is still in effect and is incorporated into the Pretrial Fairness Act by reference and by statute cite repeatedly. And the judges are still considering issues of pretrial release as well as no contact orders and other conditions to make sure that victims of domestic violence are safe. I'm going to be using the word victim throughout this presentation because we are talking about criminal court, and that is a language that is used in criminal court. So the Pretrial Fairness Act eliminated cash bond in the state of Illinois. It went into effect on September 18th of 2023 at 12 a.m. There's various ways under this law that a defendant can either be detained or released from custody, including if there's a new charge or any pending cases. So when somebody commits a new charge, when they're alleged to have committed a new charge, they're charged with a crime. That's the same as it has always been and continues under the Pretrial Fairness Act. So that is based on the alleged facts, and the standard for charging a crime is the probable cause standard. So more likely true than not that this person committed an offense. Police on the scene of an incident of domestic violence or a violation of order of protection or criminal damage to property can arrest a person, or they can issue a notice to appear or a summons. And I'll talk more about that as we get on. So certain charges, the police are encouraged to give notices to appear, such as Class B or Class C misdemeanors. Those are not detainable. So if somebody is charged with like a disorderly conduct, the police are encouraged to issue notices to appear because that person cannot be detained, but police can use their discretion and detain somebody and arrest them. A notice to appear, if a police officer issues a notice to appear, that person is given a court date in the next 7 to 21 days, and then they come to court on that date. The way we're handling that in Winnebago County is that the return date and time for notices to appear are Friday afternoons at 1:30, and those are being handled in courtroom 125. So there's no traffic court that afternoon. That's where they'll be processing notices to appear. At this date, we've had 2 Fridays for notices to appear. The first Friday, the live scan machine did not work, so there was a little bit of back and forth between the main courthouse and the Criminal Justice Center. But this last Friday, it worked perfectly fine. So these live scan machines are there. That is an opportunity for the people who are charged with an offense to be processed. So that means they're fingerprinted. So that would go on what I'm going to refer to as their NCIC, or what the Illinois State Police refer to as their rap sheet. By somebody having those fingerprints and charges put onto the rap sheet, as the Illinois State Police refers to it, that immediately impacts their ability to possess or own a firearm or have a FOID card. So that is still being done when that person is processed. So that has not changed by the system we're using in Winnebago County. They would be brought into court in front of the judge that is in that courtroom that day. They'll have their charges explained. They will have an attorney appointed if that is needed, and then they would be given conditions of pretrial release. In all domestic violence cases, specifically with intimate partner domestic violence cases, but any case involving domestic violence, whether it's a criminal damage or a disorderly conduct or phone harassment, they will be given no contact orders by the judge in that case. Now, what we're talking about for the notices to appear are likely not going to be the actual charges of violation of order of protection or the actual charge of domestic battery, or what we used to call violation of bail bond, which is now a violation of pretrial release. Those persons are being arrested and lodged because those are detainable offenses. The other offenses may be detained, or they may end up going in front of the notice to appear court and that judge. We've tried to set those dates as quickly as possible on that call. Those Friday afternoon calls we expect would be at most 30 to 40 defendants on a call, but that is a way for us to get the charges put on their rap sheet, as well as to get the no contact orders entered. Any questions yet, Nikki? All right.
No, Judge, I'm not seeing anything in the box.
Now, also the police can arrest somebody. That can either be with a warrant where the judge directs somebody to, the police to arrest somebody, or the police on the street decide to arrest somebody. When a person is arrested and lodged, we're not using the word detained anymore because it has a different meaning. So we're trying to use the word lodged, that they're lodged in the jail. So they're taken into custody. They would then appear in court before a judge on the next day. We're not having court on Sundays, but court is occurring on Saturdays. And at least thus far, it's going to be on Columbus Day or Indigenous Peoples Day on that October date. We are going to have court that day. So the person would be taken into custody and processed just like they would on any other arrest. And there's an order, that a general order that has been issued by our Chief Judge Lowry, that the Public Defender's Office is immediately appointed at 6 a.m. on that date, so that a person has an attorney. That is necessary under the Pretrial Fairness Act. They then would come to court, and just like on a notice to appear, they would be in court in person, except they would be coming from the jail. They would be told of the charges, and the judge would make a determination of probable cause. The judge has to make a probable cause determination before anybody can be detained. So the judge would make the probable cause determination. And then at that point, everything is pretty much out of the hands of the judge for a moment, because the decision would be by the state's attorney's office on whether or not to file a petition to deny pretrial release. I believe that that is what the state's attorney's office is calling them. But then the state's attorney's office would file a petition to deny pretrial release. And I'll talk more as we go on about what cases they can do that on and not. But if the state's attorney's office files that petition, then that person has a right to have a hearing on that motion to deny pretrial release. So we'll talk about that more. And if the state's attorney's office decides not to file a petition to deny pretrial release, or it's just a case that they cannot file a petition to deny pretrial release, when that person came to court, there would simply be a conditions of release hearing, at which point the state's attorney's office would say, here's the conditions of release that we think are necessary in this case, to one, make sure that that person comes back to court, two, to make sure that that person does not commit another offense, and to make sure that the victim of the offense is safe. So that's what's happening at that conditions of release hearing. So petitions to deny pretrial release are filed by the state's attorney's office. They must allege if the charge is one in which the defendant can be denied pretrial release, and it must allege the reason for moving to deny pretrial release. That hearing can be held immediately. So oftentimes in our initial appearance court, which we used to call bond court, which is in courtroom B, The hearing can be held right away. The state's attorney's office has turned over to the public defender or the private attorney, if one enters on the case, everything that they have. So if they have police reports, if they have any recordings of any statements, any witness statements, the state's attorneys often in the domestic violence cases, in cases alleging anything related to domestic violence, are looking into that person's background to see if there's any old police reports, if there are any old orders of protection. They're doing this on as large a basis as they can. I had Saturday court, not this past Saturday, but the one before, and the attorney there had orders of protection, had information about warrants in cases in Lake County. So they are getting all the information that they can, that they believe is relevant to why the court should deny pretrial release. The state or the defense can make a motion to continue that hearing. If the person is charged with a misdemeanor, the continuance can be for 24 hours. If that person is charged with a felony, that hearing has to be held within 48 hours. Sunday is not at this point being used as a date that it's continued over there. It's complicated, and honestly, I can't say I understand all of it, but there's a statute on statutes, and that would say that Sunday is not a business day, so that date does not count. So usually if a judge in initial appearance court is in court on an afternoon, they're going to try to get the hearings done that afternoon. A misdemeanor, they could set the hearing over to the following morning or afternoon. A felony, they can set it over. It has to be within 48 hours. So at the hearing, the judge has to understand, and what comes on is to understand that under the statute, all persons charged with an offense shall be eligible for pretrial release. So that's the lens that the court is looking at the petitions for and everything through, is that that person is to be eligible for pretrial release. So the burden is on the state to prove by clear and convincing evidence. And there's no definition of clear and convincing evidence. It's more than probable cause. It's less than beyond a reasonable doubt. It's closer to beyond a reasonable doubt. So what happens is the state has to prove that by clear and convincing evidence that proof is evident or the presumption is great that the defendant committed a qualifying offense. And I'll talk more about what those offenses are. So they are often using factual summaries. We used to call those probable cause statements, and the police officers would write a probable cause statement that just to show that the offense occurred. Well, the state's attorney's office has trained law enforcement that they need more information in those factual summaries. So they are lengthy. They describe much of the evidence that the state would be wanting to present. The state has to prove by clear and convincing evidence that proof is evident or the presumption is great that the defendant committed a qualifying offense. If the state cannot do that, and there might be reasons why they can't, maybe they don't have enough information. Maybe they're going to ask for continuance. Maybe there's an allegation of great bodily harm and they don't have the information of what that great bodily harm is. So that could be a reason why maybe the state couldn't prove by clear and convincing evidence that the defendant committed a qualifying offense. But if the state is able to do that, and I'd say in a majority of cases they can, that they prove that, then the next thing is the state has to prove by clear and convincing evidence again that the defendant poses a real and present threat to the safety of a person or persons in the community based on the articulable facts of the case. So what the state's attorney's office is then doing is saying, here's why this person poses a real and present threat to the safety of a person or persons or the community based on what they have said in the factual summary. But there might be other things like other orders of protection or more information in an order of protection, or maybe there's other police reports. So this is when the state is allowed to bring in other information to show why this person poses a real and present threat to the safety of somebody. If they're able to do that, then also the state has to prove again by clear and convincing evidence that no condition or combination of conditions can mitigate the real and present threat to the safety of any person or persons or the community based on specific articulable facts of the case. So when we're talking about what could be conditions of, when we're talking about no condition or combination of conditions, we're talking about what conditions of release. Can a no contact order mitigate the real and present threat to the safety? Can getting that person a curfew, getting that person not to use drugs or alcohol, like what condition or combinations of conditions could be put on that person on their pretrial release to make sure that that persons or community are safe from that person. So generally in these cases, the states is making the arguments as to why none would be available. And again, they have to show that by the standard of clear and convincing evidence. And then often the defense attorney is going to be suggesting, well, how about this condition or this combination of conditions, which would mitigate the real and present threat to the safety of any persons or the community. Stalking and aggravated stalking have different standards. So I put that on a separate screen so that can be talked about, because in that case, in addition to the state's attorney having to again prove by clear and convincing evidence that that crime occurred, the state's attorney's office has to show by clear and convincing evidence that the defendant poses a real and present threat to the safety of a victim of that alleged offense of stalking or aggravated stalking. So it's not to the community, it's not to random people, it is to that specific alleged victim. And further, by clear and convincing evidence that denial of release is necessary to prevent the fulfillment of the threat upon which the charge is based. So in a stalking or aggravated stalking case, that's a different hurdle that the state's attorney has to prove by clear and convincing evidence. So what charges are eligible for detention? Sometimes we've been calling them by shorthand detainable offenses, but I don't get the impression that the courts, the appellate court likes that. So these are the charges that are eligible for detention, all non-probationable felonies. So specifically, again, to domestic violence cases, that could include a home invasion. That's a Class X felony, that's non-probationable, so that would be a charge eligible for detention. Also, forcible felonies are eligible for detention. And the statute itself defines forcible felonies. The criminal code also defines forcible felonies. They are different. The Pretrial Fairness Act defines forcible felonies differently than the regular statute, but that could include any a case in which force or threat of force is used, and they're specifically outlined in that. So forcible felonies could include like an armed robbery or a robbery, something like that. Again, stalking or aggravated stalking, those cases are eligible for detention. In some cases might fall into multiple categories of this, so the state could allege in their petition multiple different ways that the case is eligible for detention. Also, violations of an order of protection or a violation of a stalking no contact order or a violation of a civil no contact order are detainable, whether misdemeanor or felony. Domestic battery, whether misdemeanor or felony, or aggravated domestic battery, those are eligible for detention. Most sex offenses are eligible for detention. The ones that aren't are like ones that are rarely charged, like bigamy, things like that. But most sex offenses that you can think of that would apply in a domestic violence case would be eligible for detention. Human trafficking, certain gun offenses, and certain other crimes that don't have a lot to do with domestic violence may be eligible under this standard of dangerousness. Also, we might see in a domestic violence case, felony animal abuse or animal abuse cases, those could be, a felony animal abuse could be detainable, in certain DUIs. So DUIs that there might be great bodily harm or death would be a DUI that might be eligible for detention. And then an attempt of any of these would also be detention eligible cases under this standard of dangerousness that I've been talking about. Now, there's other charges that could be eligible for detention, not under the dangerous standard, but under the standard of willful flight. So that would include Class 3 felonies or greater. So when I say Class 3 felonies or greater, it's a Class 2, Class 1, Class X, or murder. So Class 3s and up could be eligible if the state alleges willful flight. So there's not a huge definition that we have yet of willful flight, but it's intentional conduct with a purpose to thwart the judicial process to avoid prosecution. So it's not just somebody failing to appear in court that would make them a willful flight, but maybe they've been charged with escape before. Maybe they have fled the jurisdiction before. Maybe there's an aggravated fleeing. I mean, there could be a number of different ways that the state could allege willful flight. So again, they would have to prove by clear and convincing evidence that this defendant charged with a class 3 or greater felony is a danger under the willful flight standard, or is likely to commit willful flight with a purpose to thwart the judicial process to avoid prosecution. So a lot of the domestics are probably not going to fall in this category, but it's still something as a catch-all for class 3 and greater felonies. So what happens at a detention hearing? So a detention hearing, you know, it could take a relatively short time, maybe 15 to 20 minutes. It could take an hour or so. It just depends on how the evidence is presented and what evidence is presented. The state can proceed by a proffer. So what a proffer is just the state saying, here's what we believe the evidence would show. It's just them offering or telling the court that they
Someone wasn't unmuted. I've muted them, Judge.
Okay. So that could be what the facts are of the present case. So like I said, the court would have access to the factual summary, but maybe the state's attorney's office has gotten further reports, or maybe they've gotten a statement by the victim, or maybe, you know, there's other information about the present case that they want to present. They could call a police officer to testify. They can introduce exhibits, and they can just make an offer, which is them telling the court what they believe the reports show. They can also show facts from other reports or information from the victim. Maybe the victim came in to get an order of protection and talk to a victim services provider. Maybe there's other reports of alleged conduct with that same victim or with other victims that show that this person is violent. Maybe there's other information that they have. All of that can be brought in. If there's prior orders of protection, that can be brought in and proffered and told about to the court. If the defendant has a history of non-compliance with court orders, so maybe they have been charged with violation of bail bond in the past, or maybe they've been charged with escape, or maybe they have been charged with a violation of order of protection. The information is helpful to the court, and so the state could present information on their non-compliance with prior court orders. Maybe there's been probation violations, different things like that. They can also make it known to the court the defendant's prior criminal history and anything else that the state's attorney thinks is relevant to the court's decision. So often at these hearings, the state wants to give information, the defense may object to it. It's just like any other court hearing. And then it's up to the judge to decide if they're going to take and listen to that evidence and anything that would be relevant to that court's decision. At the detention hearing, the defendant is in person and is represented by an attorney that has had the opportunity to review the paperwork that the state has filed, as well as any of the reports, orders of protection, or evidence that the state is relying on. The defense attorneys are often meeting with their clients in the jail in the morning so that they can be ready in the afternoon, so that they can go over everything with them, because the defendant has an opportunity to meaningful representation by the attorney. The defense can also proffer information as well. They don't have to call their client to testify. And of course, the defense will argue why the defendant should be released. But the burden is always on the state. The burden doesn't shift to the defense, but the defense might make arguments. So some of you may be wondering, well, what about a victim? Do they have to come and testify at a detention hearing? They do not have to. The defense can attempt to call the complaining witness to testify. However, the defense must first ask the court for permission, and the court can exercise its discretion and say no. But the court must put on the record the reasons for allowing or not allowing a victim to testify. The court must find by clear and convincing evidence that the defendant would be materially prejudiced if the complaining witness does not appear. So you can think of a situation where maybe a victim is here in court and doesn't want that person detained or doesn't want charges, and the defense attorney may want to put them on the witness stand, but it's up to the court to decide if they are going to allow that person to testify. They cannot call the victim to testify just to try to prove that the victim is lying or lied to the police. So they cannot put the victim on just to cross-examine them for the purpose of impeachment. But if that victim or witness has information, the court will hear arguments and then the court will decide. But the court also has to consider the emotional and physical well-being of the victim. So this was obviously added to the Pretrial Fairness Act, and so it's important that the judge takes that seriously. It's important that the attorneys make the necessary arguments and that the court makes a good record as to why they are or are not allowing that victim to testify. So if the victim is there because they just want to see what's happening and they're with a victim services provider or an advocate, the defense can't just say, oh, I see, you know, Miss X is here and I'm going to force her to testify just so that I can cross-examine her about what she, you know, told the police. But sometimes victims do appear in court because they want to tell the court that the alleged conduct did not happen or that they don't want the no contact order. So again, it would be up to the court to decide whether or not to allow that victim to testify at a detention hearing. Obviously, for the purpose of this discussion, I'm talking about domestic violence cases, but that would apply to all other cases. But I'm just pretty much trying to focus on domestic violence for this presentation. So specifically, the statute outlines in domestic violence cases considerations that the court has to follow. I have them laminated on my bench and I look at them. I've given a copy that's laminated on the bench for the initial appearance. So any case that's involving domestic violence, again, it does not have to be the charge of domestic battery or violation of order protection. What the court is going to consider are these factors. Does the incident involve harassment or abuse as it's defined in the Illinois Domestic Violence Act? So harassment would mean knowing conduct that is not necessary to accomplish a purpose that is reasonable under the circumstances or would cause a reasonable person emotional distress and does cause emotional distress. And abuse under it means physical abuse, harassment, intimidation of a dependent, interference with personal liberty, or willful deprivation. So that could include a home invasion. That could include a burglary or a residential burglary. It could include a sexual assault or a robbery. It could include a criminal damage to property, anything that would be under that for domestic violence cases. If the charge alleges that, then the court, the judge, should be making these considerations and making a record of those considerations when the court makes their decision on the detention or not to detain and what conditions of release if they do decide to release the defendant. So the court should be looking at whether or not the defendant has a history of domestic violence or a history of other criminal acts, looking at the defendant's mental health. Is the defendant a past, present, or potential threat to any other person? Does the defendant have access to deadly weapons or a history of using deadly weapons? Does the defendant have a history of violating the orders of any court or government entity? So again, prior orders of protection violations, prior violations of a stalking no contact, prior violations of what we then called bail bond, even trespassing, if they've been banned from a location and they've continued to commit trespassing. Those are all factors for the court to consider because obviously the court is looking at, will this person follow the conditions of pretrial release? And knowing that they haven't followed conditions before is a factor for the court to consider. Does the defendant have a history of substance abuse? What was the nature of the relationship at the time? Was there a recent separation or breakup between the defendant and the victim? Has the defendant expressed suicidal or homicidal ideations? What was the severity of the alleged incident? How long did it last? Was there a weapon used? Was there physical injury? Was there a sexual assault? Was there strangulation? Was the victim pregnant? Were any pets abused? Was there a forcible entry to access the victim? Also, the court will be looking at, has the defendant exhibited obsessive or controlling behaviors towards the victim? Has there been stalking, surveillance, isolation? And the court would also look at the domestic violence screening instrument. I am obviously no expert on that, but from what I've been told by smart people from probation, the domestic violence screening instrument looks at the risk of that person recidivating while out on pretrial release on a case. It's a scale that goes from 0 to 30. 11 is considered high risk. So the higher the number, the higher the risk level. So that's something that the court is looking at. And we get all this information from the pretrial services report. A lot of this information is given to us by probation officers that are here really early in the morning, meeting with defendants and gathering this information. These are validated assessment tools. So there's the pretrial risk assessment, I think it's the Virginia, and then the domestic violence screening instrument. The judge is given all of this information about the defendant's criminal history, their drug and alcohol use, their any substance abuse treatment, any mental health issues, any physical health issues. That's all part of the pretrial services report, but it's also information that the state's attorney might have more information about that they want to present to the judge, or the defense wants to present to the judge. So the court would look at all of those factors and make a record of going through those factors when making a decision about whether or not to detain that person or not. Because again, at the end of that hearing, the court has to make a written decision. So you will see if you're in initial appearance court, some judges are handwriting it. Some judges, it's a fillable form on our computer. We start typing. So we have to say the specific articulable facts, why we are finding that the crime was committed by clear and convincing evidence, why we find that the defendant is dangerous, and why no conditions or combinations of conditions of pretrial release would mean that that person should be detained. So it's a lot of different factors. So now maybe you're starting to understand why it's an unbelievable amount of work for the state's attorney's office to get this information together in a very short period of time, to get it to the defense attorney, who then has to have a meaningful conversation about that with the defendant, and then to get all this information to the court, and then for the court to make a decision. So it's a lot. There's no way to say it other than it's a lot. It's a lot of work for probation, the defense, the state, for the victim services providers, and for the court. It's been a lot for the clerks that have been here in court, the court reporters that have been here. A lot of times these hearings are going well past 5 o'clock. On the weekends, they're going a lot. So just understand that's why. It's because everybody is trying to do the best amount of work that they can. And I know that it can be frustrating to people to have to stay here late, but it's important that every party gets to be heard, all the evidence gets to be presented and considered by the court, and that a good record is made. If the court determines that the defendant will be detained, then that defendant is given a court date in the courtroom in which that case is assigned. So if that person is coming to my courtroom, they would get a court date in front of me. And then often what happens in my courtroom, because we just got numbers and I apparently have 875 defendants in front of me right now. So the state's attorney's office will contact me and say, I have this person scheduled for indictment on Friday. Can we bring it in next week? So of course we want to bring it in and move it along as quickly as we can. The defendant is given the next court date and they're simply detained. There's no amount of money that they can post. There's no, the court has found there's no condition of release that will mitigate the dangerousness of the defendant. So they stay in custody. That's a huge difference. Then on every single court date that the court has with that in custody defendant, the court has to reconsider the conditions of release. So at every single court date, I would have to, or any judge would have to look at whether or not we think that person should continue to be detained. So unlike the old system, the defense attorney might file a bond motion. That's not how it is anymore with these cases. What is happening is simply that the court has to continue to relook at it every single court date and make findings. And the state's attorney's office is required to continue to keep the victim notified of court dates. The court cannot make a change in a condition of release, or if somebody's out on pretrial release and there's a no contact order, the court cannot take that away without the victim being notified of the court date. So if the defense comes in and says, well, we don't think there should be, if somebody's out of custody and released, we don't think there should be a condition of pretrial release or no contact order. The court can't take any action on that unless that victim is notified and has an opportunity to be present. So that is written into the statute. If the court decides to release the defendant, they're given a next court date, and then there's a conditions of pretrial release hearing that would likely include a no contact order with the victim, but could have other conditions of that pretrial release. If the defendant is released, there's mandatory conditions. They must appear in court. They must follow the orders of the court. They must surrender firearms and FOID cards for certain offenses, including stalking and aggravated stalking, domestic battery, and a forcible felony. It used to be a mandatory condition that the defendant could not leave the state of Illinois. That is no longer a mandatory condition. It is a discretionary condition. So discretionary conditions would include a no contact order, maybe reporting to pretrial services, no firearms on a non-domestic related offense, and any other condition that the court finds necessary to mitigate, or mitigate means to lessen, the defendant's potential dangerousness. So it could be anything as long as the court finds by clear and convincing evidence that it is necessary.
We have a question if you have a second.
Sure.
Okay. Question in the chat. What if there is a challenge with contacting the victim? What time frame is given to contact them before someone is released? I assume maybe the question is referring to the state contacting the victim.
So my understanding from the state's attorney's office is what they're doing here is that every morning, as soon as they see the arrest, they're reaching out to the victims and making contact. They're training the officers to get as good of contact information as they can. And then they are making phone calls and attempting to contact those victims immediately. There also is the notice of rights under the Illinois Domestic Violence Act that the state's attorney's office has worked hard to modify, that police officers are giving to the victim, so that they know that the next court date on the petition to detain is that next day, so that if they want to be there or be present, they can. Also, they're told about their right to get an order of protection, which I'll be talking about. A judge likely, if the person comes in front of the court and wants to change a condition of pretrial release to allow contact, my practice, and I certainly can't speak for any other judges, is I am never, ever going to change a no contact order unless I hear from that victim in person, so that I can assess the facts of the case. So that person would have to be present for me to take away a no contact order. I think most judges would probably be similar in that regard. I hope that answers the question, but if not, you can continue to put into the chat. There are also things called petitions to revoke pretrial release. Again, that is filed by the state's attorney's office. It would have to allege that, number one, the defendant is on pretrial release for a Class A misdemeanor or felony, and two, that they have been charged with a Class A misdemeanor or felony that is alleged to have occurred during the period of pretrial release. So sometimes, and this is just an example, there might be a long drug investigation and somebody's out on pretrial release on a charge, and then they end up charged with a drug case that was really committed well before that person was released. But most, that wouldn't count. But the state can file a petition to revoke pretrial release, and this happens a lot. Somebody's out on pretrial release for a domestic violence case, or really any Class A misdemeanor or felony, and then they get a new Class A misdemeanor or felony, then that the state is generally always filing a petition to revoke pretrial release. So maybe it's a violation of the no contact order and they're charged with that. Maybe somebody's charged with a DUI when they're out on pretrial release. The state can, at their discretion, file a petition to revoke pretrial release. The court can also ask that one be filed. So every morning, we as judges are told about who's been arrested, and if we want the state to file a petition to revoke pretrial release, we can tell the initial appearance court judge and ask them to ask the state to do that. The state shall, meaning they must, file a petition to revoke pretrial release when the defendant is on pretrial release and is charged with a violation of an order of protection, or was previously convicted of a violation of an order of protection with the same protected person. So that's a mandatory of the state filing a petition to revoke pretrial release in that circumstance. So that's the only mandatory where the state has to, but the state is filing them very often on these petitions to revoke pretrial release. That hearing must be held within 72 hours of that petition being filed. So the state in initial appearance court has a timestamp, and when they're about to file their petition, they put it in the timestamp, and it's stamped with the date and time that it is filed. And the judge in initial appearance court makes a determination if the defendant will be held pending that hearing or if the defendant will be released. If the judge orders that that person is held, they're put the very next date on that judge's court calendar, the judge that has the original charge. So at that hearing, the burden is on the state to prove by clear and convincing evidence that no condition or combination of conditions of release would reasonably ensure, 1, the appearance of the defendant in court, and 2, prevent the defendant from being charged with a new felony or Class A misdemeanor. So in domestic violence cases, this particularly is coming up if somebody commits another crime against that same victim and they're charged, or they're out on pretrial release on a domestic battery or criminal damage to property, and they violate the conditions of that release and are charged with a Class A misdemeanor of that. Then what is happening generally is it's put immediately on the court's docket, and then the judges are setting the hearing, not necessarily on that first day that you're there, but within that 72-hour time frame. So for example, there were 3 cases yesterday in front of Judge Pacanini in initial appearance court that the state filed petitions to revoke pretrial release hearings on that came to my courtroom today. I had them in front of me this morning, and then their attorney was here, and I ordered the state to turn over all relevant discovery and information, and then the defense attorney to review it with their client, and then they will be back in 2 days on Thursday for us to conduct the hearing, either Thursday morning or Thursday afternoon. That allows the state to reach out and make victim contact. It allows all the information to be exchanged, and then we would have that hearing. If the court decides to revoke pretrial release, then that person is held. Again, there's no amount of bond. The court can revoke pretrial release, the defendant is held. The court can release the defendant. The court can modify the conditions of release, and the court can sanction the defendant. My favorite is the written admonishment. I don't know when I would have time to write down to somebody like, bad job, you shouldn't have done that. But you can, the court can do that. You can do an oral admonishment, and they can be sanctioned up to 30 days in custody. It's unclear from the statute whether day for day credit applies to that or if it's 30 actual days. But that's what the statute says. Every single decision made by the court relating to the pretrial release and conditions of release can be appealed, both by the state and by the defense. So at every hearing that the court does, I have to admonish or tell that person what their appellate rights are. It is an expedited appeal, meaning that that appeal has to be filed by the defendant or the state within 14 days. They're immediately on the defense, it's indigent, would be able to get the appellate defender, and it's immediately put on the appellate court's docket, and their decisions will be made expeditiously, quickly. But we remain jurisdiction, we continue to have jurisdiction here. So our case carries on. In some appeals, you might hear like everything pauses. That's not how it is. We carry on, and it could be that the defendant maybe has pled guilty and gotten a sentence by the time we got that appeal back. So that's just a new thing, is the appeal. So for defendants that were in custody prior to midnight on September 1st of 2023, the jail doors did not open. Everybody did not go running out at that time, like was the fear. But what we're doing here is the burden is on the defense to file a motion to reconsider conditions of pretrial release, or it's often being shorthanded to motion to release. So what the statute says is that we cannot hold a defendant in custody with a financial requirement for their release. So the court has to consider the same factors in a petition to detain hearing. Are there any conditions or combination of conditions of release that would mitigate the defendant's dangerousness to a person or the community? So that monetary bond that was put on somebody prior to September 18th, that would be considered under the law now a condition of release, and that monetary bond can't be that. Just like if the court ordered somebody to have a scram device and they couldn't pay to have the anklet to monitor their drug or alcohol use, they cannot be held in custody just because they can't meet a financial requirement of their release. So we're having these hearings already on a regular basis. If the case is a detainable offense, the court must hold the hearing within 90 days. So if it's any of those offenses that I listed to you earlier, then the judge has to hold that hearing within 90 days. If it is a class 3 felony and above, like I talked about with that willful flight standard, the court must have that hearing on reconsidering the motion of pretrial, the conditions of pretrial release within 60 days. And if it is a non-detainable offense, under any standard, the court must have that hearing within 7 days on that motion to reconsider the conditions of pretrial release. Presumably, judges are not stretching these out to 90 to 60 days. We're fitting them in as quickly as we can. I know some of the other information that we'll be getting in these lunch and learns will be about what the state's attorney's office is doing to look at people who are in custody, potentially making victim contact. Often at these hearings and at the petitions to revoke pretrial release, the state is pulling jail records to present to the court to show that even while in custody, they're violating no contact orders. So that information that might take time for the state to get together and get turned over to the defense, and the defense to have a chance to meet with their client about it. So that would be a delay. It used to be with bond motions, we would do the hearing within like 3 days. The state had a right to 3 days notice, but right now we're just trying to fit it into our schedules as the best that we can. That's how those are being handled. Again, we are giving time for the state to attempt to make victim contact. So it's often not going to be okay tomorrow. And if it is, like I had some that were set this past Monday, the state said they needed more time. Well, they still have time. So I continued it to give them more time to get the information together that they wanted to, because they were detainable offenses. Marcy's Law continues to apply. So a victim can still assert their rights under Marcy's Law. They still have a right to notification of all hearings. They still have a right to make statements and be present at the same as the defendant. So oftentimes at these detention hearings or petitions, motions to release or petitions to revoke pretrial release, there are statements being presented to the court relating to what the victim has to say, why they want that person detained or not detained. And of course, the state's attorney is not the attorney for the victim, but they still will tell the court. So even if the prosecutor disagrees with what the victim has to say, they still have a duty to present that information to the court. Another thing to bear in mind is that criminal orders of protection can be sought at the detention hearing. So that can be done Mondays through Fridays, the same as it is now. A victim can show up to court. So what we're doing to try to alleviate a busy court call in front of the initial appearance judge is that I am located in courtroom C right next to initial appearance. So I would be the first go-to for any criminal orders of protection. So they didn't bog up Judge Paganini's call. And if I'm unavailable, Judge Gibbons, who's trained and he's on the other side in courtroom A, is doing those criminal orders of protection. The benefit of that, of course, is that the person can be immediately served while they are in custody. So there's not a service issue, but they would still have the right to a victim services provider. If it's an intimate partner case from Remedies, or an advocate from Remedies, or a victim services provider from the state's attorney's office, they could go to DVAM and fill it out. And we do have a plan on Saturdays. Again, the state's attorney's office has really gone above and beyond. They're reaching out to the victims on Saturdays, letting them know they have a right to a criminal order of protection, that they can come in on Saturday and get one, or they can come in during the week. We do have through the judges and through Remedies an after hours order of protection that can be sought, but they can come to court between 1 and 1:30 before the afternoon call starts at 1:30. And I have to stress that the Saturday calls have been overwhelming these past 2 weeks with the number of arrests and detention hearings and the length of time. So it is important that it's done prior to the call so that the call can be done as early as possible. But the state's attorney's office is doing a fantastic job. They did one this Saturday, helping the victim fill out the paperwork. And then there is a clerk here, which we're so grateful. There's an order of protection clerk that is here to number it up. And we're able to get that into the system right away on Saturdays. So that's still a work in progress, as everything is, because as we continue to get, see the numbers, see how the flow is going, get opinions from the appellate court, anything is subject to change. But that's how it is right now. So holy moly, I did that well and good timing. So I'm gonna be happy about that. Are there any questions that anybody has about anything that I've said? I stopped sharing my screen. Any questions, Nikki?
I don't see anything, but anybody is welcome to unmute themselves if you have questions.
Okay.
Hold on 1 second. There's a
Has a question?
Oh, Kristen has a question. I didn't unmute Kristen. I don't see you on my screen.
Hi, I just have a question. So if someone is being released, say someone came up here to the Domestic Violence Assistance Center for that criminal OP. I know they have court 1:30, they're being released. How long does it take them from that decision to be released? How long does that person have to get that order to the jail to get them served there.
All right, so if somebody is detained and they're gonna be going to court at 1:30, the way the order of the court is going is the first cases that are called by the judge that day are cases where the state's not filing a petition to detain. So those would be brought in at 1:30. They're brought in person. They do the conditions of release hearing. That takes whatever amount of time that it takes that Saturday or any weekday to get that done. Then on the cases where the court is doing a detention hearing, those would start after that, maybe sometime at 2 or 2:30, they'd start doing the detention hearings. And then those detention hearings would go as long as they went. Somebody is not immediately released from the jail. There's not a detention hearing. There still would be time for the jail to process them, get them back to the jail. So it usually takes a couple hours, I would say, a good period of time for that person to be released. If we knew that there was going to be an order of protection in that case, the judge or anybody could let the jail know, the state's attorney's office, hey, you have an order of protection coming. We want to get that person served while they're still in custody and then get that over to them. But if the person comes in at 4 o'clock and the defendant was up and released at 1:30, they might not get served if they're still in custody. But it's not a quick process to be released from the jail. They don't walk right out of court. If the judge releases them, they go back into the holding cell. They have to then go back and be processed. So it is a longer process.
Thank you.
Any other questions?
Well, I really appreciate this opportunity to talk to you about it. I've been in the work group that has been working on this for, I don't know, an eternity. And every time I talk about it, it helps me understand it a little bit more. I really feel free to ask questions if something comes up after this. Obviously, I can't talk about specific cases, but if there's things that you're seeing that, hey, this would be a better way to handle it, or this is would be helpful, always we're welcome for feedback. I can't tell you, like, I see Jody Giroux here, like probation and pretrial has been such a helpful partner. The jail has been such a helpful partner, the clerk's office. This is a group effort by the judiciary, and it's just so impressive to see all the work with the jail, the state's attorney's office, the public defender's office, probation, to everybody working together so well. So I'm sure a lot of you on this call work in those departments and just know how appreciated you are by myself and the other judges that have been on the work group. And we're happy to continue to answer any questions and get any feedback from you. And also, with this being Domestic Violence Awareness Month, I speak for a lot of people on this call of how necessary you are as partners with domestic violence, not only supporting victims and survivors and children that are part of domestic violence, but also trying to rehabilitate persons who cause harm and defendants and offenders to make sure that this cycle stops. So I hope you take a moment to congratulate yourselves during this month and know how appreciated you are. And don't forget to take care of yourselves, because this is not an easy job to have and an easy group to work with. So take care of yourselves as well. Anything else, Nikki?
Just a few closing, keep an eye out for an email from the Sign Up Genius with a link to an evaluation. We do use the evaluations for multiple purposes, grant reporting, but also to kind of guide the presentations that we offer. Also, as I mentioned, this was the first of 5 lunch and learns that we'll hold throughout the month. So every Tuesday at noon, we hope to see you. I know many of you signed up for all 5 of them. So that's really exciting for us, but continue to share that opportunity. And we are thankful for your attendance today. So I think that's everything. Next week, we are doing domestic violence in the intersection with stalking. We'll be joined by Alex Ronning from the state's attorney's office and Becky Winstead from Remedies. So we hope to see you next week. Otherwise, you're free to go right on time, Judge Clifford. That's impressive. It is impressive. Yeah, thank you. So thanks everybody for your time today. Bye.
Thank you. Thanks, Nikki. Jody Drew is so nice. She puts us nice things in the chat.